Hey, whoa. Hey, everybody. Welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have an update in the Blake Lively versus Justin Baldoni case that I want to go over with you this morning. The recent disputes have been over potential sealing of testimony and exhibits involving third parties. So the first one to come out, which I actually did a video on earlier this week, was Isabela Ferrer. Isabella played the younger version of Blake Lively's character Lily in the film, and she filed a letter asking the judge to keep her testimony, her deposition testimony, permanently sealed. Her reasoning was that these were intimate scenes that she was testifying about, that should be, I guess, her privacy should be considered. I'm not doing a very comprehensive, thorough recap right now. I'll link to the video that I did before in the comments if you want to know about that. And also that there was some testimony about a non-party, like an additional third party's religious affiliation. Don't have much information about who that was or why, but she asked that the judge permanently seal her deposition testimony so the public would never see it based on these things. My initial response to that was, kind of the same response I had to all of the third-party requests for sealing that came out. I wanted to keep an open mind because I feel very, I think third-party privacy is something that I feel is very important. So I want to keep an open mind about the process. So if somebody asks who's not a party to this lawsuit, who's not Blake or Justin or Jamie or anyone involved in the actual lawsuit, I want to keep an open mind as to how much of someone's privacy should be protected. But at the same time, it's like these things are relevant to the court claim, so the public has a right to know. And most people who watch my channel will know I'm very biased towards Justin and the Wayfarer parties. I think that Blake's claims are pretty bogus. I don't believe any sexual harassment or anything like that took place. But I have been trying to keep an open mind as much as I can as far as the third parties go. If you're newer here, you might not know that Blake Lively issued a subpoena for my information earlier on in this lawsuit. I think it was back in July, asking for my credit card numbers, my bank account information, my geolocation data for a time span that preceded the time I ever talked about this lawsuit in general, and it was bizarre. So I know firsthand what it's like to feel like the court system is being used to violate your privacy. And people have said, Isabella was a witness to a lot of this stuff. She's a material witness in this case, as I said. And I agree with that it is a little bit different. But the reason I'm so careful to not pass judgment too early on is that if those privacy laws are not taken seriously and at least considered, then it could affect all third parties in the future. Like if any of those content creators had successfully been subpoenaed, if they didn't know about it and they didn't, fight it within the required deadline, then who knows how much of our private information she could have gotten, and who knows if we could have kept it private from the public at large. So my opinion is just that everyone should have the right to ask to have this information sealed and have a right to make their case as to why certain information should be withheld from the public. And I wanted to keep an open mind as to what was being asked and the reasoning behind it. That being said, now that I have read the Wayfarer party's response to Isabella Ferrer's request for continued sealing, I can give a more elaborate opinion, let's put it that way. So let me show you guys what they had to say and we'll talk about it. Miss Ferrer played the role of young Lily Bloom in the film It Ends With Us. In opposing the Wayfarer party's summary judgment motion on her hostile work environment claim and other claims, plaintiff Blake Lively relied heavily on Miss Ferrer's alleged experiences on the set of the film. So that right out of the gate is a good reason why this is important to be shown to the public. Thus, a strong presumption of public access applies to Miss Ferrer's testimony on that subject. Indeed, this court correctly held in its November 26, 2025 order that the presumption of public access is at its peak in the context of dispositive motions. So basically, this isn't just like random text messages, random evidence. This is evidence that's going to be relative to the judge's ruling on these motions for summary judgment or judgment on pleadings, etc. So if there's information in there or information from other third parties in this discovery that's going to help the public understand why the judge and the courts who, they're funded by the taxpayers, make the decisions that they make, then the presumption of public access, the public's right to access to that information, might outweigh a lot of other things. So you have to weigh the interest of privacy of a third party who didn't bring this lawsuit forward, who's not a defendant in the lawsuit. You have to weigh their privacy versus the right of the public to understand why decisions are made by the systems that they pay for. And I think not just in this case, but in different cases in general, I've been, branching out a little bit lately. It's a complicated thing sometimes. I know there are a lot of times where I'm like, yes, we should be able to see that because I totally want to see it. But I'm like, hold on. Should we allow courts to essentially violate somebody's privacy that way? And unfortunately, the answer is, if you're being brought into a lawsuit like this as a third party, the answer is probably yes, a lot of the time. But that's the reason I've tried to remain so impartial from a public opinion standpoint. You guys know I'm not a lawyer, but from a public opinion standpoint, I've tried to remain as much as I can so impartial when it comes to these sealing requests. It's like there's a lot at stake here on both sides of the ball. Denying public access to information is such a slippery slope, but also violating someone's privacy is such a slippery slope. But in this case, it appears that, the public interest in that information and the public's right to that information is going to outweigh the privacy concerns. And so we'll continue to read, and I'll get into that a little bit more. Ms. Ferrer, nevertheless, seeks to seal the testimony, stressing she is a non-party who did not voluntarily choose to become involved in this litigation, and erroneously implying that the Wayfarer parties dragged her into this case in August 2025 when they sought to serve her via alternative means. So this is where they're going to have to set the record straight. And the mainstream media ran with that narrative, right? That Justin Baldoni was dragging Isabela Ferrer into this, and Isabella Ferrer's crazy ass lawyer wrote that the subpoena was somehow a harassment to her. Like, I know Omar had some choice words about that. Omar, the Tilted lawyer, who I haven't streamed with about this case in a while, but a lot of you guys probably remember how that went. But she tried to say basically that Wayfarer was dragging her into this and that they did something improper and harassing by trying to serve her with a subpoena. And Kevin Fritz, the attorney for the Wayfarer parties, is about to set the record straight here. He says, more accurately, in December 2024, Ms. Lively's initial pleadings complained about a scene in the film involving Ms. Ferrer's portrayal of young Lily. In March 2025, Ms. Lively issued a subpoena to Ms. Ferrer to produce documents. In June 2025, Ms. Lively served her amended initial disclosures in which she identified Ms. Ferrer as someone with knowledge of matters relevant to Ms. Lively's claims of harassment and retaliation. The court may recall that given Ms. Ferrer's contention in August 2025 that she has been improperly drawn into litigation, the Wayfarer parties offered to stipulate that none of the parties will use any communication to, from, or concerning Ms. Ferrer, or any testimony from her in any manner in this action. So they basically said, you have a clean cut out on this, as long as all parties agree to it. The Wayfarer parties and Justin said, we don't need to use your testimony or anything like that, as long as all parties agree not to do so. And here they clarify, Miss Lively did not agree to such preclusion or any similar remedy. We reiterate our proposal. So Blake said no to not involving Isabella. Isabella said Justin and the Wayfarer parties were harassing her by trying to subpoena her and involve her in this lawsuit when she had already had her lawyer agree to accept service of Blake's subpoena without any resistance. And also Blake Lively's team was the one that said no. We refused to leave her out of it. Ms. Lively's second amended complaint alleges that certain Wayfarer parties created a hostile work environment in violation of federal and state employment laws by, among other purported incidents, filming a simulated sex scene. So they're not actually having sex. Obviously, this isn't a porno, in which young Lily and her boyfriend, the character Atlas, lose their virginity, which moment Ms. Lively acknowledges is referenced in the book on which the film is based. Furthermore, Ms. Lively's amended initial disclosures state that Ms. Ferrer has information relating to the party's alleged conduct, the sexually discriminating, harassing, and other inappropriate or unwelcome actions, conduct, or comments made during production of the film, complaints or discussions about the work environment or conduct on the set of the film, the production, editing, cut, and creative process associated with the film, efforts taken to market or promote the film, publicity surrounding the film, the retaliation campaign alleged by Miss Lively. So that's a whole lot of information that Blake Lively says Isabella Ferrer has. And yet she, through her attorney, tried to blame Justin Baldoni for dragging her into this lawsuit. Okay, then. The motion contends that sealing is appropriate because, according to Ms. Ferrer, her deposition testimony contains sensitive details regarding the filming of intimate sexual scenes and the religious affiliation of another non-party who is not involved in this litigation. So the religious affiliation thing of the other non-party, who I can't say for sure who that is or what would have been said. That's what got me when it came to the privacy stuff. I was wondering if maybe just that part should remain redacted. But apparently the Wayfarer parties are saying there are no sensitive details sufficient to overcome the strong presumption of public access to judicial documents at this stage. But the Wayfarer parties are saying there are no sensitive details sufficient to overcome the strong presumption of public access. Ms. Ferrer's actions in the simulated sex scene at issue as young Lily are already in the public domain because the film was widely distributed. Moreover, Ms. Ferrer's deposition testimony does not contain any details, let alone non-existent graphic details, about the simulated sex scene in the physical sense. So the thing that got me about the intimate scene stuff as well was there might be stuff about other non-parties or very intimate details about someone's body or something like that that were in the deposition testimony that I feel like maybe doesn't need to be made public. I think I gave some really ridiculous examples of what I might be talking about just to demonstrate my points when I initially came across her motion to seal, but it doesn't really sound like that's what we're looking at. So I wanted to keep an open mind. I did, and now it appears, based on what I'm reading, that her right to privacy is not going to overwhelm or overcome the right of public access, especially because those scenes are obviously out there already in a movie. So people have seen the sex scenes. And they note here that instead, Ms. Ferrer testified about who was or was not present for rehearsals of the scene, whether she was or was not concerned about anything that occurred during such rehearsals, whether the scene was filmed or not, and her comments to the film's intimacy coordinator following the filming of the scene. So none of this to me seems like intimately private details. I don't regret keeping an open mind. I don't. I think that I always want to keep an open mind when it comes to, personal rights and privacy and stuff like that. But I knew that once the Wayfarer parties responded, I might change my mind, and I have. So, remarkably, after Ms. Ferrer completed her work on the film, she expressed her gratitude to Mr. Baldoni, stating that she had an incredible experience and praised him for creating a comfortable, safe space for her. Accordingly, Ms. Ferrer cannot legitimately contend that her testimony concerning a scene that Miss Lively squarely placed at issue herein is irrelevant to the court's judicial function on a dispositive motion for summary judgment. Ms. Ferrer's request to seal her testimony concerning the religious affiliation of another non-party is equally unwarranted. So this was probably the part that concerned me most, right? Because I'm like, who is the innocent other third party who's being maybe brought into this? But what they're saying is basically that that person also testified, right? So I didn't know that. The testimony was provided by Ms. Ferrer upon questioning about the promotion of the film and the participation of certain individuals in such events. The exclusion of Mr. Baldoni from promotion of the film, who orchestrated his isolation, the purported reasons for those actions, and the public's negative reaction thereto are all relevant to disproving Miss Lively's claim that the Wayfarer parties engaged in a so-called retaliatory smear campaign against her. We note that the non-party referenced by Ms. Ferrer has not moved to seal any portion of his/her own deposition testimony, which included the same topic of religious affiliation. So that right there, if they themselves did not move to seal this stuff, then fuck it. Why should she have the right to seal that if they themselves are not concerned about it? If she's really concerned about that person and they're saying, I'm not worried about it, then she should not have that stuff restricted. Although Ms. Ferrer claims that she is particularly vulnerable to harassment and misuse of her deposition testimony and at risk of professional harm because she is a working actress, she is not entitled to greater rights than any other fact witness in this case. Furthermore, it is well settled that generalized concerns of adverse publicity and reputational injury, the only potential harms articulated in the letter motion, cannot justify an order sealing a core judicial document. All right, so now that I have a lot more information, and from the sound of it, doesn't seem like her testimony really needs to be sealed. I don't think that it's really going to cause that much harm to her professional reputation if people hear that she was involved in an intimate scene in a movie that was widely shown with her being involved in an intimate scene. If the person with the religious concerns is not raising the issue of sealing themselves, then I don't think that she should really have that as a consideration. In a general sense, I still want to maintain some distance and objectivity in evaluating whether or not third-party testimony, that kind of thing, should be sealed. I feel like, privacy in that regard is something that I feel strongly about, because I don't want our courts to be used as a weapon against random people when lawsuits are on the table, you know what I mean? So I want to remain impartial to an extent when I first hear requests like that. But as I said, in this case, my mind was changed when I heard a little more detail about what was actually being discussed. So, all right. Thanks everyone for watching. I appreciate it. And I will see you all soon. Don't forget to hit the like button for me. That helps me out. So bye.